Hi everybody, this is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today I'm going to do a video based on a request that I received from one of my viewers. And this was about a New York City construction site accident, verdicts and settlements that involved either a fusion surgery or a fusion surgery to the neck or lower back along with a spinal cord stimulator, which is a type of device that gets implanted after a fusion surgery for people that have really serious back or neck injuries. So let's get into it. Here's the first case. And I wanted to say, I only found 3 cases, right? So this is a pretty niche area. There aren't that many cases, but I found 3 cases. The first case was in New York County, which is Manhattan. And it was a 2008 index number. That means the lawsuit was filed in 2008. The date of the settlement was June 27th of 2011. The plaintiff was 49 years old, and he had an expert who was an orthopedic surgeon. The defendant had 2 experts, a neurologist and an orthopedic surgeon. And so what happened was, the facts were that on September 6th of 2007, the plaintiff, who was a union-affiliated stone setter, was at a construction project at the Queens campus for St. John's University. And he was directed to retrieve water from a pail that was between a large trash container and a dormitory that was under construction. And so while doing this, he was struck by a 3-foot by 5-foot piece of plasterboard that fell toward the container from the dormitory's 2nd-story window. So I guess he's like trying to get something, right? And he's like, near the trash. And then because the whole dorm building is under construction, this plasterboard falls from the building and hits him. And he claimed that he sustained an injury to his back. So he sued the owner, which is St. John's University. He sued the project's general contractor, which is Structure Tone. And he argued that the defendants violated the New York State labor law. And so, yeah, when you sue either for a falling object or a falling worker because of gravity, you would sue the GC, the general contractor, as well as the owner or the landlord. Those are the 2 defendants that are liable under the New York State labor law. And so the plaintiff also testified that before his accident, he had seen debris being thrown into the container from above and had complained to his employer's foreman. And his lawyer claimed that the incident stemmed from an elevation-related hazard as defined by 240 subsection 1, and that the plaintiff was not provided the proper safe equipment that is required by the statute. And they also claimed that the site was not properly safeguarded as required by labor law 241 subsection 6, and that the defendants violated the general safety provision of labor law 200. And so the general contractor's project manager testified that workers were instructed to throw debris from the window, but only at the end of the workday. He claimed that the debris that fell had slipped out of a worker's hand. And so the plaintiff moved for summary judgment on labor law 240 and labor law 241-6. The judge granted liability as to labor law 240, and the jury was asked to determine damages. Now the damages, the injury, plaintiff's attorney argued that the plaintiff had a worksite accident in June 2001 in which he sustained a herniated disc at L5-S1, and that the plaintiff was disabled from that accident but underwent surgery and was out of work for 5 years until the subject accident, when he started working for less than a year. On the date of this accident, the client went to see his primary care physician. He attempted to work for about 3 months after the accident and continued to follow up with his primary care physician. He also underwent physical therapy and pain management. He was initially diagnosed with stenosis at all levels. That's basically a narrowing, where there's not enough room for the nerves that exit the spinal canal to go where they're supposed to go because there's a lot of narrowing. And he also was diagnosed with an injury to his thoracic spine. That's the middle back. The neck is the cervical and the lumbar is the lower. So then the client also sustained a lumbar spine injury, and he argued that the subject accident aggravated his pre-existing back injury, And in April 2009, he had a fusion from T10 all the way down to S1. Oh, wow, from T10, which is where the thoracic ends, all the way to the sacral, right? Because you talk about L5S1, which is just one level, but from T, that means basically from L1, well, T10 is above L1, all the way down to S1. That's a large fusion. So you're talking about T10, L1, L2, L3, L4, L5, and S1. So that's a 7-level vertebral fusion. That's pretty serious. So after the surgery, the client claimed that he suffered reflex sympathetic dystrophy, RSD, as well as erectile dysfunction as a result of the surgery. He continued to be in pain and could not work. He had 3 epidural injections and eventually had a spinal cord stimulator placed, though it provided no relief. The client never returned to work. His expert orthopedic surgeon gave the opinion that the client's injury was related to the subject accident and was an aggravation of his pre-existing back condition. The client sought recovery of damages for his past and future pain and suffering. His wife sought recovery for loss of consortium. The defense lawyer argued that the client's injuries predated this accident, and the defense's expert orthopedic surgeon and expert neurologist also gave the opinion that the client's injury was pre-existing. The defense counsel argued that the client had already been diagnosed with failed back syndrome from his June 2001 accident, and that his alleged injury was not a result of the subject accident, but because of his back already being in poor condition. The defense counsel also questioned whether this client's claims of reflex sympathetic dystrophy and erectile dysfunction were true. And so the case settled pre-trial. The case settled for $3,500,000. So not a bad settlement. I would think, like, all those injuries, if the RSD was really true and he had that many levels of a fusion, it would be more. But not bad, I guess. The next case is, let's see here. The next case is long, I guess. I'm trying to get to the front page. Okay, here it is. The next case is in Suffolk County. And the carpenter claimed that there was no safe scaffold provided at the job. So this is Suffolk County out in Long Island. This, the date of the settlement was January 25th, 2023. So about, a year and a half ago. And the client was 42 years old. He had experts, economist, he had a vocational rehabilitation expert, he had a spinal surgeon, and he had a life care planner. And the defendants had an orthopedic surgeon, neurologist, pain management, vocational rehab for the defendants, economist for the defendants, and a life care planner for the defendants. And the insurance company was CNA. And this incident happened on September 26th of 2019. And so what happened here was the 42-year-old carpenter, he was working for a general contractor. He was working on a construction project at a fire department in Bayshore, which is out in Suffolk County. And so he used the Baker scaffold provided to him in order to install crown moldings just below the ceiling, which was just less than 11 feet in height. And while using a nail gun to install the moldings, the client fell backwards off the scaffold. And when he landed on the ground below, the scaffolding fell on top of him. And so he claimed that injuries to his neck, back, and shoulder. He sued the property owners, which is the fire department, and the Bayshore Fire District. And the lawsuit alleged that the defendants failed to provide a safe workplace and that the defendants' failure constituted a violation of the labor law. Now, he couldn't sue the general contractor because that was his employer, right? We said he worked for the general contractor. So you can't sue your employer, that's workers' comp. But he could sue the Bayshore Fire Department. So the parties disagreed on the height of the scaffolding. The plaintiff argued that he was provided with a 6-foot Baker scaffold, while the defendant argued that the scaffolding's platform was 4 feet. And plaintiffs argued that the subject scaffolding did not have railings as it was old and the platform was bent. And the plaintiff also argued that a protective covering was placed on the floor in the area of the accident to protect it during the work, but that the masonite covering was old, wet, and bent, making it difficult for the scaffold, which was sitting on top of it, to remain level. In addition, the plaintiff's attorney argued that there was no alternative safety device available for the client to perform his work, and that the client was not provided with any type of fall arrest system, creating a hazardous work condition. So the client had 3 witnesses, eyewitnesses, as to liability, and each was prepared to testify as to the circumstances related to the fall, including but not limited to the lack of alternative safety devices, the warped floor covering, and the deficiencies with the scaffolding at issue. So the client's counsel asserted violations of 240, 241.6, and basically had 200 in there as well. Those are the labor law statutes. They're going to be asserted in pretty much every labor law case, mostly. And plaintiff's lawyer moved for summary judgment, arguing that the gravity-related accident is the exact type that the New York State Legislature sought to prevent against by passing Labor Law 240. And on August 30th, 2022, the judge granted the motion, finding that the accident was caused by the absence or the inadequacy of a safety device of the kind enumerated in the statute. So now the injury was a herniated cervical, thoracic, and lumbar disc, C3, C4, C4, C5, C5, C6, T2, T3, T3, T4, T4, T5. So basically a lot of them. I don't want to go through every level. L2, L3, all the way down to L5, S1. And he also claimed he sustained a bulging thoracic disc at T6, T7. And in addition, the client claimed he sustained internal derangement, supraspinatus tendon tear of the superior labrum from the anterior to the posterior, which is a slap tear, all to his right shoulder. And he alleged that he continues to suffer from radiculopathy, which is the radiating or traveling pain, and that he had limited range of motion. So the accident occurred on a Thursday. The client was not scheduled to return to work until the following Monday. However, he returned to work that Monday. He was sent home because of his noticeable injuries. So he first sought medical treatment 12 days after the accident, and he was discharged the same day. Although he testified that he complained about his back at his initial medical visit, no lumbar complaints were recorded in the hospital's records, nor was there any lumbar treatment. His first recorded back complaint for the lumbar was 32 days after the accident, when he was hospitalized at Good Samaritan University Hospital, where he underwent an emergency laminectomy on November 5th, 2019. And after the emergency laminectomy, he had an unsuccessful course of conservative treatment. He had to go have an arthroscopic surgery on his right shoulder, a 3-level cervical fusion on March 8th, 2021, a 4-level lumbar fusion on June 14th, 2021. And unfortunately, he claimed that his nerve pain increased following the lumbar fusion, leaving him in constant pain in his lower right extremity, the lower right leg. So then he claimed that since he found no relief from his pain, a permanent spinal cord stimulator was implanted in 2022. So he never returned to work. Had the case gone to trial, a vocational rehab expert would have testified that he was incapable of returning to work and unable to undergo rehabilitation to learn how to perform sedentary work. And as a result, he set forth a significant lost earnings claim. He doesn't say how much, but significant. And the plaintiff's expert would have testified that he'll require future visits with a spine specialist, orthopedic doctor, pain specialist, and physical therapist. They also would have given the opinion that the client would have required future diagnostic testing, changes to the batteries in his spinal cord stimulator, a device removal and reinstallation procedure, injections and medications. In addition, they gave the opinion that he would need both cervical and lumbar fusions based on the anticipated adjacent level syndrome, which is a known medical issue. The plaintiff's physical medicine and rehabilitation specialist provided the current costs of the anticipated treatment, and the plaintiff's expert economist applied the expected inflation rates for those costs. In addition, the resultant cost of future health care was claimed as part of the economic damages. The defendants argued that this client had prior accidents where he injured his neck and back. The prior injuries resulted in open lumbar laminectomies in 2005 and 2006. They argued that the client treated for neck and back complaints following a 2013 motor vehicle accident, and they argued, or they rather questioned, whether a subsequent incident occurred between the date of the accident and the first hospitalization, which happened 32 days later. And the defense theory developed based on differing liability descriptions and conflicting date of accidents in the hospital records. Another factor was the client's delayed complaints and treatment regarding his lower back. While the initial lumbar laminectomy at L2 appeared to be medically necessary, the defense counsel questioned how the client could wait a month with a disc that had burst. While it was determined by the defense experts that the surgery was medically necessary, causal connection would also have been questioned, given that, according to the defense, the client was a poor historian and appeared with a black eye and bruises that were not present immediately following the accident, which he gave inconsistent testimony about. The defense counsel hired their own experts to evaluate the client. Had the matter proceeded to trial, the defense, through the use of their medical experts, would have attempted to demonstrate that the alleged injuries to the neck, including the subsequent surgery, were not caused by this incident, as the diagnostic testing post-accident revealed pre-existing degenerative changes without any evidence of an acute injury, as well as multi-level spondylosis. Further, the defendant's experts would have compared the films gained before and after the incident and used models to establish the lack of any significant change to the cervical region post-accident. Even though the defendant's spinal specialist conceded that the L2 disc emergently operated on was related to the accident, he denied any other treatment or procedures were related to the subject scaffold fall. And the defendant's vocational rehabilitation expert, gave the opinion that the client was capable of obtaining various forms of gainful employment. So yeah, that's basically the case. So this case, it settled for $9.75 million. So a really nice settlement out in Suffolk County, almost $10 million. He must have had a lot of economic damages because, Suffolk County is a more conservative venue. So you're talking about the guy had like a 7-level fusion with, you would think he would have economics too in New York County, but he only settled for like $3 million. And this guy settled for like $10 million in Suffolk County, which is a worse venue. So he must have had crazy economics. He must have had like 15 million in economics, I'm guessing. Okay, and the final case. The final case is a settlement also. All these cases are settlements. This one happened in the U.S. District, Southern District of New York. And this one settled in July 28th of 2023, so about a year ago, let's say a little less than a year. And the client was 47 years old. And what happened here, I'll give you the brief rundown. What happened here was on June 28th, 2018, the client, a 38-year-old building engineer, and another client, so there were two clients, a 47-year-old foreman, were working in a building at 5th Avenue when the freight elevator they were riding in suddenly dropped 2 or 3 floors, abruptly stopped. They claimed that the incident caused each of them to suffer significant injuries to their spines. And there were 2 construction projects going on. So, So there were companies that maintained the elevator. There were contractors that were performing work on both projects. And they sued everybody, it sounds like. And then there was a lot of lawsuits between the defendants for indemnification. And there were motions for summary judgment. And the motions were still pending at the time that the case was settled. The plaintiff's counsel argued that the building's ownership and management and the elevator maintenance company failed to properly maintain the elevator. And so it wasn't really a labor law case, it was more like an elevator case, but construction related, I guess. And then the injury, so one of them, I'll call him M, just for the first letter of his last name. I don't want to give away any names or anything, but I'll call him M. The M client, he sustained injuries, a herniated disc at L4, L5, C5, C6 as well, so neck and lower back, and bulging discs in the neck. And he had a lumbar discectomy at L4, L5 in 2018. And the surgery was unsuccessful, so then he needed a lumbar fusion with the implant of a permanent hardware. And then he had a spinal cord stimulator implanted on May 5th, 2021. And then he had a cervical fusion at C5, C6. And so that was the M client. Now the G client, he sustained herniated discs at C4, C5, and he had cervical radiculopathy. He underwent an anterior cervical discectomy at C4, C5, C5, C6, and an anterior cervical arthroplasty at C4, C5, C5, C6. And he was examined by a physical medicine and rehab specialist along with a spinal surgeon. And they gave the opinion that this was all caused by the injuries and that he needed surgery and is disabled. And so they had lost income, loss of Social Security retirement income, future healthcare costs. And then the defendants argued it's not causally related, it's degenerative, the same old spiel. It's going to be the same pretty much. That's the only thing they could argue. So the plaintiffs negotiated a pretrial settlement. This was the settlement. The M client was going to receive $8,166,000, and the G client would receive $4,083,000. And so they just break down how much each defendant or each insurance company would pay. I don't think that's really particularly interesting. Like one is going to pay 2.1, another one's going to pay 1.6 or 166,000. But the elevator company's insurance company paid $4 million, and then another one paid $2 million, and then there was another excess policy that provided another $5 million coverage. So out of that $5 million excess for umbrella, they paid $2 million out of that. And so, yeah, that's basically this case. So the total settlement was actually $12.25 million. So that's pretty nice settlement. So I hope this was helpful. Let us know what questions you have. Please like and subscribe to our channel. Please also visit us on other platforms. We're on Instagram. We are on Facebook. We are on TikTok too. And in fact, we need about 200 more followers on TikTok, and then we could start doing lives. We'll be at 1,000, and once we're at 1,000, we can start doing lives, maybe where we answer your questions just like we do on YouTube. So please like and subscribe to our channel. Let us know what questions you have. We are here for you. Our goal is helping serious injury victims and families. Have a great day, everyone. Bye-bye.